the Chief Justice of Nigeria, Kudirat Kekereekun, has said that she will not tolerate any act of corruption in the judiciary on her watch. She vows to instill the highest level of discipline in the judiciary, deal decisively with erring judicial officers who peddle conflicting court judgments. When she appeared before the Senate last week, the Red Chamber also asked to know if there are sanctions for lawyers who discuss matters before the court in the media. All right, Dr. Sam Amadi is here to look at this issue. Hello, Doc. Very warm welcome to Newsnight.
Thank you, Chris. Good evening.
I think the question here is, what does the law say about a matter in court? Can it be discussed before a court of law? Will it amount to prejudice?
Well, first is that, yes, the answer is it can be discussed. And by the way, the controlling section of the Constitution, which is Section 39, that you journalists are more, if you know more than lawyers, does not make an exemption. A lawyer or no lawyer, everybody has a right to an opinion. And the only condition where that right is controlled, if you look at subsection 3, relates to any law that may be made. So if you want to contain the right of freedom of expression, it has to be through a law. And so the question of which law has made that, and of course he talked about also protecting the integrity and independence of the court. Now if you look at the Legal Practitioners Act, it's clear on what amounts to professional misconduct. And so it lists about 4 categories. First is, a lawyer who does something that's wrong in the conduct of his case, embezzling their client's funds. Lawyer who commit a crime and convicted and no appeal. Lawyers who also involve in practices, traits, and professions that are incompatible with law practice. So those are the things that constitute professional misconduct. Now, a lawyer, the rules of professional conduct, code of conduct for lawyers, which is the rules of professional ethics, provide, if you look at section 30 to 33, 34, it talks about conduct. So the only thing there is that the lawyer who is engaged in prosecuting a case before the court cannot make prejudicial statements. So there are 3 categories here. Any lawyer
the lawyers who are involved are
in the
exempted
case from prejudicial. They can make statements, but cases that is prejudicial to or in any way, obstruct conduct. Mm-hmm. So any other lawyer who is not involved in the case has no direct professional obligation or code not to talk about the case. So the lawyer involved in the case can talk about the case, about his client's case, but he shouldn't speak in a way that prejudge to what. And the key thing about, then we talk about contempt of court. There are 2 kinds, civil and criminal. So if anybody does anything before the court to obstruct, disrupt, interfere with witnesses, especially when we use jury. If you look at the US, there are over 100 cases that have been reversed on jury interference. So jurors are banned from social media. Yeah. So there are comments that the judges can restrict them from making. We don't deal with jury system here. But if you interfere with witnesses, those are conduct or court issues order. We call it ex facia outside the court. Court issues an order, you impede it, you stop the court function. Those are contemptuous actions that the court can direct, indirect, criminal, civil. So, but the notion that lawyers who are not engaged in any case and making good faith analysis of the case, they may be wrong, they may be right, does not in any way amount to breach of any professional. So the rules of professional discipline are strictly laid down. The procedure for it, what triggers it, and in many cases, the Supreme Court, the courts have said, it must be in respect of a matter you are engaging for those conduct to be contemptuous. So you can't just say a lawyer, who makes a statement, maybe mischaracterize a case, for example, or form a very wrong opinion of a case, or even misassess the judge, or even condemn decision of a court, have nothing to do with impeding the independence and impartiality of the court. So the notion, the responsibility of lawyers, of course, lawyers have to be controlled in what they say. But the key point is that there's no law or professional code that stop a lawyer, because it's a lawyer, from discussing a matter pending. The only person who has a direct responsibility under the professional code is the lawyer engaged in that case. And his own responsibility is not to comment in a manner
that will be prejudicial or
to obstruct or influence or stop or distort proceeding. So that should be very clear. Now, it does not mean that lawyers shouldn't have responsibility. Lawyers are also, Section Rule 30 says they are officers of the courts. And so the lawyers generally help in administration of justice by clarifying. In fact, there are rules about even lawyers who are involved in the case writing their names or putting articles about the case they're handling. But nothing stops scholars, analysts, or lawyers from doing so. Now, again, the mistake does not that every lawyer is involved in litigation. There are lawyers who are involved in public policy, in public administration, in public service, in media, who are journalists. So the fact that they are called to the bar does not mean that they are seized of cases in court. So I think so that the Supreme Court or none of the lawyers should get carried away by the notion that politicians would like nobody to talk about their cases, especially those politicians who probably are seen as corrupt.
Should the Nigerian media, have looked hands akimbo with the former governor of Kogi State, who is alleged by the EFCC to have embezzled XYZ, even though the substantive matter has not opened in court? Should the media and other public, stand hands akimbo without discussing?
There's no requirement of law for the Constitution, from the Legal Professionals Act, for the professional rules of ethics that require journalists or lawyers who are journalists or public. Nobody is required not to comment about matters that are likely to end in court, that are in court. The only person who is stopped from commenting in a prejudicial manner is those who are involved,
directly
either
involved,
as parties or as lawyers in that case. Every other person has the right of fair comment. Now, if your comment is libelous,
you've used the word
fair comment. That's what I say. Fair means if it's libelous, you can suffer for that comment.
Oh yeah.
If it's defamatory, that's it. If it amounts to contempt of court, for example, you are impeding administration of justice, you are stopping witnesses,
you can be dogged.
You can be dogged for contempt, and they are proceeding for contempt. So there is no requirement anywhere to free speech because the case is coming or is in court. That's really not true, whether in the US or UK, anywhere in the world.
I think the president of the Senate was just overacting or something. I mean, are you supposed to be a lawyer, a lawmaker? And
by the way,
shouldn't he be well abreast of,
And he has very senior lawyers advising. But the point is this: why should the first concern of a senior president who is going to screen a chief justice of the federation in a country, there's several issues on jurisprudence, several issues on the role of court, on judicial supremacy, on corruption in the bench, and so on. Why should his first concern, the only concern is how are you going to dock those guys who say things we don't like?
That'll be you and I,
Who said, I mean, that's really the low, that's too low. I mean, so it's important as journalists, as public interested fellows to say to the courts and to lawyers, there's nowhere in the law that says once a matter is in court, no speech. No. Like I said, the only person who ought not to is the lawyer involved. And his own is not even that he can't speak. He can address the media about his case, about his client.
That's case is in court.
That's why
this is what we're asking for.
Even when they come out to trial, they explain to you, my lord made an order, so, where the order, we're going to appeal the order. They have a right. What they cannot do is statement that will be prejudicial to the case or in any way undermine the integrity. You see, the thing about the judiciary is the integrity and independence. So comments about the quality or merit of cases has nothing to do with integrity or with independence. So it's important to say that nobody goes in fear and say, oh, we're not supposed to comment. No, we should all speak out because it's public duty also of a lawyer. The first lawyer in Nigeria, Sapara Williams, says it's a lawyer's responsibility to direct his society. So this is public interest. Speaking about the cases, commenting about them scholarly and intelligently helps judges to improve. By the way, I've done a case before where Justice Mukta, on local standard, we published our view about this case. The next case, he said, he read it, and he agreed. So it's part of public legal education when learned scholars and analysts review cases that judges have done. Judges learn. Judges learn from everything.
Absolutely.
So, but when they are making a decision, they base it on the case before them. Only untrained judge will be wondering what a pundit is saying on television. His job is to look at the case before her or him and make a decision. So it doesn't matter
whatever anybody goes to say.
And that's very important to bear that in mind.
Thanks so very much, Dr. Sam Amadi, Arise News analyst, for shedding great light on that issue raised by the president of the Nigerian Senate, Godswill Akpabio.